You're listening to KSG Podcast. This is a short, crisp, concise, exam-oriented, edited editorial for civil services aspirants. In this podcast, we are going to talk about a giant leap for women's health. The source for the content is the Free Press Journal. In allowing single and unmarried women whose pregnancy term is between weeks 20 and 24 to access safe and legal abortion, the Supreme Court of India took a giant leap in women's health care. In a sweep, the bench led by Justice DY Chandrachud wiped away the false distinction between married women and others seeking abortion in the 51-year-old Medical Termination of Pregnancy Act of 1971. The law disallowed unmarried women from legally accessing abortion even within the 24-week term. In doing so, the law had created an unrealistic and false binary between married women and others when it came to medical termination of pregnancies, and had unfortunately put the legal stamp on a popularly held misconception that pregnancy can only be the outcome of a marriage. The law, while ahead of many other countries even in the global north, worked against single or unmarried pregnant women who were forced into illegal and unsafe abortions, raising the risks to their general health and well-being. Besides the risks involved, accessing such abortions was fraught with dishonor and humiliation. The bitter truth in the women's reproductive health sector is that single and unmarried women, often of a young age, do become pregnant and need safe and legitimate abortion care. The Supreme Court has now made it possible for them to get it. However, this does not mean that the situation on the ground changed in their favor at the end of the day that the Supreme Court bench gave its judgment. The reproductive healthcare sector, especially medical and paramedical staff in abortion clinics, must be made aware of the important change and sensitized to the fact that marriage and pregnancy have been delinked, at least legally. The idea of reproductive autonomy lies at the heart of the Supreme Court judgment, as articulated by Justice Chandrachud, who invoked Article 21 and Article 14 of the Constitution. This is a lesson from the developing world to the United States in the developed world, where its apex court took away in June this year abortion rights and the autonomy of women to decide whether to carry their pregnancies to term or not by overturning the landmark Roe v. Wade judgment of 1973. That one act made it possible for states to ban abortions, and reports are that at least 20 states immediately moved to limit access to abortion with varying terms of the pregnancy. The 1970s had witnessed an uprising across the world with feminist movements demanding more autonomy and agency of women over their bodies. Indian courts took a step ahead to expand the autonomy. The US, unfortunately, went several steps behind. Now, what does the law on abortion say? The Medical Termination of Pregnancy Act allows termination of pregnancy by a medical practitioner in 2 stages. After a crucial amendment in 2021 for pregnancies up to 20 weeks, termination is allowed under the opinion of one registered medical practitioner. For pregnancies between 20 to 24 weeks, the rules attached to the law prescribe certain criteria in terms of who can avail termination. It also requires the opinion of 2 registered medical practitioners in this case. For pregnancies within 20 weeks, termination can be allowed if A. The continuance of the pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health, or B. There is a substantial risk that if the child was born, it would suffer from any serious physical or mental abnormality. Now, the explanation to the provision states that termination within 20 weeks is allowed where any pregnancy occurs as a result of failure of any device or method used by any woman or her partner for the purpose of limiting the number of children or preventing pregnancy. The anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health of the pregnant woman. The phrase any woman or her partner was also introduced in 2021 in place of the earlier married woman or her husband. By eliminating the word married woman or her husband from the scheme of the MTP Act, the legislature intended to clarify the scope of Section 3 and bring pregnancies which occur outside the institution of marriage within the protective umbrella of the law. For both stages, within 20 weeks and between 20 to 24 weeks, termination is allowed where any pregnancy is alleged by the pregnant woman to have been caused by rape. The anguish caused by the pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman. Now, what is the effect of the judgment? The court's purposive interpretation states that the common thread in Rule 3b is a change in a woman's material circumstance. While the ruling recognizes the right of unmarried women, it leaves the enforcement of the right to be decided on a case to case basis. The ruling states it is not possible for either the legislature or the courts to list each of the potential events which would qualify as a change of material circumstances. Suffice it to say that each case must be tested against this standard with due regard to the unique facts and circumstances that a pregnant woman finds herself in. Now, this means the decision will be in the hands of the registered medical practitioners, and if unsatisfied, the woman can approach the court. That's it for this podcast. Thank you so much for listening. To join KSG India courses and to crack the IS exam, visit ksgindia.com. You can also get a PDF of this podcast on ksgindia.com. Thanks for listening and do subscribe to our channel.